Appeal in the matter of Leicester City Council in Parmar.
Yes, Mr. Allen. I can tell you that we have read the judgment of the Employment Tribunal, of the Employment Appeals Tribunal, and the skeleton arguments.
I'm grateful, Lord, Your Ladyship. I appear with Mr. Livingston for the appellant, local authority employer. Learned friend Mr. Panesar and Ms. Crawshay Williams appear for the claimant. We all appeared before the Employment Appeal Tribunal, and Mr. Livingston and Ms. Crawshay Williams appeared at first instance before the Employment Tribunal. I've agreed, my lord, with Mr. Panesar that I will take no more than 2 hours this morning, and if I can, I will take less time and save up 5 minutes to respond to anything that he might say. Mr. Livingston is going to address your lordships on ground 2 concerning disclosure, which is the area which we thought is particularly rooted in what happened at the tribunal. And I will address you on grounds 1, 3, and 4.
Right.
You have a bundle and a supplementary bundle and authorities bundle. There is no additional paperwork that I'm aware of. At the outset, I think I should acknowledge that we come before the Court of Appeal having had our somewhat longer list of grounds of appeal thoroughly rejected by His Honour Judge Tayler in the Employment Appeal Tribunal. That we failed to convince His Honour Judge Tayler is a failure of my powers of advocacy, clearly. But we have taken on board comments made by the Appeal Tribunal about the number of grounds of appeal which have been greatly narrowed. However, we do remain of the stance that there were multiple errors of law in the Tribunal's judgment and reasons.
Do you have any issue with the Tribunal's explicit self-directions on the law?
The parts of the Tribunal judgment in which they set out what the law is are not the subject of any argument. It's the application and the self-evident lack of application of those principles that we take issue with. The judgment and reason sent to the parties on the 22nd of March 2023 determined that the claimant largely succeeded. It's not specifically in the judgment, but this court will have, of course, appreciated that she didn't succeed in relation to detriment 1, but did succeed in relation to the other 5 detriments. Sorry, the other 4 detriments of the 5. It's worth noting, as the Employment Tribunal noted in paragraph 1 of its decision, that a victimisation claim which the claimant had sought to bring was not, in fact, before the tribunal. And the bundle before this court contains an amended particulars of claim at page 175 and onwards, which contains the victimisation claim. However, there having been no permission to amend, it was the original particulars of claim, which is also in the bundle at page 170, and the original grounds of resistance in the bundle at page 133, which were the pleadings on which this hearing took place.
Yeah.
Just looking at the 5 alleged detriments, and in particular the 4 that were upheld at paragraph 55, page 118 of the bundle, I just wanted to note a couple of points, particularly in relation to the dates on which things happened, just for the purposes of clarity, which should assist the arguments that we seek to make. So the date of the transfer at 55.2 is effectively the same date as the other matters which took place on the 12th of January 2021. Causing the disciplinary investigation to be carried out is explicitly stated to be on the 12th of January 2021. In relation to issue 4 at 55.4 of 118, the several disciplinary investigation meetings, so the tribunal effectively divided that into 3, found for the claimant on the first 2 meetings, 19th of February 2021 and 22nd of April 2021, but not in relation to the third on the 7th of May 2021. And then in relation to issue 5, that is again, as you can see, expressly dated 12th of January 2021. So 2, 3 and 5, all 12th of January 2021. Only the meetings, matters which occurred on other dates. We can also see from page 118, paragraph 56, that the claimant relied on a hypothetical comparator before the tribunal. That's something that was clarified by the claimant's representative at the hearing, as I understand it.
Yes, because that's not quite the way it was put in the ET, the particulars of claim are attached to the ET1, I think. So that was clarified at the hearing.
So that was, I've asked Mr. Lewison about that, and this was also a matter which came up before the Employment Appeals Tribunal, Your Ladyship, that the claimant's counsel at the hearing clarified that she was relying on a hypothetical comparator.
Yes, I confirm that.
I'm very grateful.
Thank you very much.
So the claimant has since been dismissed, which had in fact happened by the time of the Employment Tribunal hearing. It's noted in paragraph 12. But at the relevant time, she was the head of service for Locality West in the social services function of the local authority. She directly managed a number of team leaders, and they themselves managed individual social workers. At the same level as the claimant were two managers who, two heads of service who feature in the decision. Now, everyone's referred to by initials. I don't know why that was. It wasn't at the request, I understand, of either of the parties. But AE in late 2020 and early 2021 was the acting head of service for the contact and response area. And HM was the previous head of service for contact and response. And an important background fact, which is noted at paragraph 13, page 112, is that the relationship between C and R, contact and response, which was HM and AE's area, and Locality West, which was the claimant's area, was a poor one. So I didn't want to say anything else about the background. Clearly it is set out in both the Employment Tribunal and Employment Appeals Tribunal's decisions. Just in broad outline as to what the errors of law were. Round 1, we say the errors were failing to distinguish between a statutory comparator, whether that is an actual human being or a hypothetical statutory comparator, and an evidential comparator. And also within ground 1, failing to consider the extent to which the circumstances of potential evidential comparators were the same or different to the claimant. On
The function of the evidential comparators is to help the tribunal decide on the statutory comparator, isn't it? That's what they are there for.
the statutory comparator in this case being the hypothetical one.
Yeah.
Yes.
So why should you distinguish? They're just a question of evidence, aren't they?
Well, I'm going to come in due course to the detail with reference to the case law, but essentially it's about similarities and differences in order to be able to place weight on the evidence that is derived from the evidential comparator. And I will take you to that. I'm just, if I may, going through as a matter of bullet points what the grounds are. At ground 2, we say the error is in drawing adverse inferences from alleged disclosure failings without considering whether they potentially shed light on the actual discrimination complained of and on the actions of the alleged discriminator. Ground 3, we say the error is to have approached most of the respondent's non-discriminatory explanations for the treatment of the claimant by asking, was it a good reason or was it a reasonable position to take, rather than merely, was this the genuine reason? And in relation to ground 4, we say the tribunal were in error in upholding a separate claim of direct discrimination about the meetings, this is issue 4, without separately considering the reasons given by the respondent for its actions in inviting the claimant to those meetings.
But if the inception of the investigation was self-discriminatory and the meetings were part of that investigation, don't they all fold into the same point?
Well, Lady No, in that the proper comparator for the meetings is someone who's in a disciplinary investigation process. And clearly anyone in a disciplinary investigation process is going to be, it would be unfair not to invite them to a meeting at which they can give their side of the picture. And indeed, the outcome of this process was that the claimant didn't.
There may be circumstances where it's perfectly legitimate to have meetings, but these meetings, according to the ET, were in the context of an investigation which they had found to be motivated by racial bias. So doesn't that taint everything that happens in the course of the investigation?
Well, Lady, I can see that it's quite possible to say that matters such as meetings, which were a consequence of an act of discrimination, would not have happened were it not for the act of discrimination. But they are not separate acts of discrimination in themselves. And if they are to be considered as separate acts of discrimination, the tribunal should go through the process of saying, was there less favourable treatment in relation to these? And is there a reason for having these that's put forward by the respondent that we need to separately consider because separate people were involved or a separate person was involved in relation to the second one, and that they occur at different times from the other matters, which is one of the reasons why I wanted to set out the different months on which things happened. So that's the summary of the grounds.
Can I just ask you a question about that?
Yes.
It might be thought that being asked to a disciplinary meeting when the underlying disciplinary charge is baseless is in and of itself a detriment.
Yeah, I agree. It might be said, and therefore a tribunal, when looking at such an issue, would need to look at exactly that set of circumstances, would need to look at whether in the particular circumstances of this particular claimant, she was treated less favourably than a hypothetical comparator would have been, and whether the specific reasons put forward by the respondent for inviting her to that meeting, to both of those meetings, were adequate responses if the burden had shifted to the respondent and whether they showed that there was no discrimination. This tribunal didn't do that. What it says is, for the reasons given above. And the reasons given above, to the extent that they can be divined, are all about the commencement of the disciplinary itself. What we say is not enough when you have a separate issue relating to separate dates, and in one of the dates a separate person. Very briefly before I turn to the detail of ground 1, the approach of the Employment Tribunal to the determination of the issues is referenced at paragraph 65, page 120. And what the tribunal said was that there was no argument advanced by either party that this is one of those cases where discrimination or the absence of discrimination is so clear-cut that it's not necessary to go through the two-stage process. Now, as it happens, this isn't an appeal point, but as it happens, that's wrong, because Mr. Livingston did argue in written submissions exactly that, and the written submissions are towards the back of the bundle. But be that as it may, what I take from this paragraph is that the approach that the tribunal says that it was intending to take was that it was going to go through the two-stage process. And I mention that because the starting point, I think, for consideration of the conclusions should be at paragraph 76, page 122, which is at the heart of many of the conclusions. And paragraph 76 is the start of the 3 paragraphs of the conclusions which appear to be on stage 1 of the process, the 2-stage process. But at the end of paragraph 76, oddly, the tribunal state, remembering that this is only at stage 1, we are satisfied that race played a part in her decisions. There is no other credible explanation. It is only further on from paragraph 79 and onwards that the tribunal actually sets out its response to the explanations put forward by the respondent. And in the preceding paragraphs, so up to paragraph 76, there's no record of any direct evidence as to race being a reason. I bring your lordship to this
What
because
about paragraph 70? Where they say we arrive at that conclusion for the reasons below, but in essence. And they go on to say in that paragraph, a number of comparable situations where a disciplinary investigation might have been instigated, Miss Lake chose not to do so when it involved employees of a different race.
Because, my lord, that is the basis on which the tribunal draws an inference. So when I said there's no evidence in the preceding paragraphs of direct evidence of race, I mean there's nothing other than these inferences that are drawn from these supposed comparators.
Isn't that only to be expected? Who's going to say, I disciplined this person because she was of a different race?
Well, Lord, the point that I seek to make is that when the tribunal says at its first stage, when it's just talking about shifting the burden of proof, we are satisfied that race played a part. They're not saying, which is the way that the test is set out, that race could have played a part, subject to any explanations that we may be about to hear. They've gone straight to a conclusion, in relation to race. So I say only that should sound a note of caution in the way that the tribunal reasoning is approached. That again, it's not an appeal point in itself. Ground 1.
Sorry, I'm sorry, I'm not following that at all. So you're saying it's not an appeal point, but it sounds a note of caution. Well, what's your submission about it? Have they gone wrong there or not?
Can I take you through ground 1, and I think it will answer the question that you have asked.
Right.
Thank you. So there are 2 evidential comparisons made by the Employment Tribunal. The differences in treatment of co-workers with behaviour allegations, who are said in paragraph 76 to be HM, AE, and JR. Findings of fact are made about behaviour allegations in relation to HM at paragraphs 14 to 20. So that's in relation to HM, first the swearing matter, and then the email which she sent. In relation to JR, things are a little less clear, but at paragraphs 21 to 23, there are findings of fact which involve JR. And then in relation to AE, there are no findings of fact in the tribunal reasons concerning behavioural allegations concerning AE. What you have is merely a finding in relation to going to someone's house to collect a badge, laptop and locker key at paragraph 25. Email exchange at paragraph 29. And then from paragraph 31 onwards, findings of fact relating to AE as a complainant rather than as a person accused of behavioural issues. The other comparison made is, of course, the treatment of other Asian co-workers, referred to at paragraphs 53 and 54 and 70.6. And there's no detail there given about the circumstances in which those people were disciplined. My learned friends in their skeleton paragraphs 6, 7 and 8 set out why it is that evidential comparators play an important part in employment tribunal decision making. We have no argument with the matters set out in paragraphs 6, 7 and 8 of my learned friends' skeleton, nor the parts of the authorities that they refer to therein. However, when looking at other parts of the authorities, it is clear, I'll take your lordship to those, that a tribunal must take care to consider differences as well as similarities when looking at evidential comparators. And I am fortunate in making this argument that Mr. Justice Kavanagh, in the case of Martin and St. Francis Xavier, which is at tab 10 of the authorities bundle starting at page 195, Mr. Justice Kavanagh summarises some of the leading authorities and also some recent authorities on this point.
But, I mean, his judgment is extensively cited by His Honour Judge Tayler in the EAT.
And indeed, in a further reference, Mr. Justice Kavanagh cites His Honour Judge Taylor's.
Yeah, and that also cited by His Honour Judge Tayler.
Yes. So if I can take you to some matters which are worth highlighting in particular, taking it in the order that Mr. Justice Kavanagh took matters, so at page...
You wanted to turn up the authority?
My Lord, yes, please.
Page are you on?
So it starts at page 195. It's a direct race discrimination case centred on a black teacher being disciplined for being late on exam day. And the first matter that I wish to take you to is at page 211, where Mr. Justice Kavanagh is citing Lord Scott in Shamoon. So page 211. And in particular, at page 211, in the middle of paragraph 109 of Shamoon, where Lord Scott tells us that the usefulness of the tool at that point in Shamoon being comparators in the broad sense, as well as evidential comparators in the narrow sense, will in any particular case depend upon the extent to which the circumstances relating to the comparator are the same as the circumstances relating to the victim. The more significant the difference or differences, the less cogent will be the case for drawing the requisite inference. And then specifically in relation to evidential comparators, at the end of paragraph 110, their evidential value will, however, be variable and will inevitably be weakened by material differences between the circumstances related to them and the circumstances of the victim.
Sort of obvious, isn't it?
Yeah.
Well, lady, I would have thought so, but this isn't, I would suggest, the approach that the Employment Tribunal took, in that there is no reference to differences in relation to the evidential comparators that they sought to rely upon.
One infer from that the tribunal didn't think the differences mattered.
Milady, I'm sorry, I didn't hear.
Can one infer from that the Employment Tribunal thought that the differences did not matter?
Milady, not when differences were specifically brought to the attention of the Employment Tribunal in the submissions of the respondent, and those differences were set out in the written submissions from Mr. Livingston, and not when the differences, and of course it's not a matter for this appeal court to determine, not when the differences do give rise to some cause for concern that there may need to be a consideration of the differences, and not when one of the people, AE, is someone in relation to whom the Employment Tribunal makes no findings of behavioural allegations, and not when another, JR, is someone who is of a different grade to the claimant, and in relation to whom the Employment Tribunal's findings of fact do not clearly set out anything which seems comparable to the situation of the claimant. And further to that, not when the tribunal itself have not set out the specific circumstances of a hypothetical comparator, so the specific circumstances of the allegations against the claimant that it is taking into account when constructing that hypothetical
The
comparator.
allegations against the claimant weren't specific. That's part of why the tribunal thought that the disciplinary process was a bit of a nonsense.
Well,
The essential point, Mr. Allen, isn't it, that this appears to have been a work environment where some people sent off intemperate and rude emails to one another and upset other people. And there was quite a lot of it going on. Why does one need any more than that?
because, Milady, the evidence which was before the Employment Tribunal as to the circumstances which were relevant were a situation in which the claimant's circumstances were of someone who was accused of operating an oppressive regime which left those under her charge scared, frightened, and afraid to be seen to help others in the organisation. This is in the supplementary bundle in the complaint made by SCC. It's between pages 3 and 7, and specifically at page 4.
Wasn't reflected in the matters that were the subject of the disciplinary investigation. That language wasn't used. There's nothing about an oppressive regime. I mean, the ET set out what the
Paragraph 35, maybe I think is the, it's either 35 or 38, let me find it. Forgive me, it's 39
Of what?
of the Employment Tribunal's decision, page 116.
I mean, this is much blander. Failure to behave in accordance with code management leadership standards, blah, blah, blah. Failure to ensure people you directly manage behave in accordance with agreed standards.
And
There are no specific allegations, and oppressive regime is not used.
created an environment that is detrimental to individuals is used in the third point.
Yes.
But the
Oppressive regime is totally different from an environment that's detrimental to individuals.
Milady, the decision that was made by Ms. Lake to commence a disciplinary investigation, reminding ourselves that it's the start of an investigation, not the bringing of charges at a later stage. So that I quite accept that when you're at the stage prior to a disciplinary hearing, in which you're informing someone of what the specific allegations are against them, that you need to be more specific. At the stage in which you are investigating what has come in as complaints from two individuals, SCC and AE, then it is the material on which those people have supplied to Ms. Lake that needs to be the basis for considering whether her decision to commence a disciplinary investigation was, those are the matters which are the circumstances in which the claimant was treated and the circumstances in which any hypothetical comparator has to be looked at. And it goes beyond just the oppressive regime. You have accusations in the emails from AE, which the tribunal have only focused on the first one, which they refer to at paragraph 70.5. But there's a full set of emails from AE which include specific allegations of the claimant targeting an individual worker running a team with a long reputation of intimidating and unhelpful behaviour, victimising a colleague, and being vindictive and unprofessional. These are all set out in the supplementary bundle in the emails from AE at pages supplementary 9 and 12. We also have Ms. Lake's evidence of the claimant being someone who'd been spoken to informally in the past, but who hadn't acknowledged any concerns or had reflected back any concerns to problems with others, rather than accepting any personal responsibility.
Didn't the ET make some findings about that when they were considering the respondent's explanation?
Yes, there is a finding at 79.4 in which the ET made findings that Ms. Lake did say that there were 3 examples in which the claimant had failed to acknowledge past issues, but the tribunal rejected the suggestion that that those things were the reason, or part of the reason, that Ms. Lake had taken the decision that she had in commencing the disciplinary investigation. But these are circumstances, relevant circumstances, for the comparison exercise at stage 1, which, if not articulated, mean that the construction of the hypothetical comparator, which is not an express task that this tribunal has engaged in, the construction of the hypothetical comparator may have gone wrong.
Don't you have to go further and say it has gone wrong?
Well, I mean, we do say that it must have gone wrong. And the evidence for that lies in the way in which these comparable situations are looked at. So paragraph 70, at the bottom of page 120, it says, we arrive at that conclusion for the reasons below, but in essence it's because in a number of comparable situations where a disciplinary investigation might reasonably have been instigated, Ms. Lake chose not to do so. So HM, AE and JR, their situations are elevated to comparable situations without any reference at any point in the decision to any differences to the situation involving the claimant. So HM, AE and JR were not accused of operating oppressive regimes, victimization, targeting people, running teams with a long reputation of intimidating and unhelpful behavior, or being vindictive. They're not people for whom there is any evidence that they've been spoken to informally in the past and concerns were not acknowledged. In HM's case, it's precisely the opposite. The evidence is that in relation to the swearing, for example, this is recorded by the tribunal at paragraph 14, pages 112 to 113. HM accepted that her conduct was inappropriate and unprofessional. It's a similar point in relation to the email which she sent, in which the evidence before the tribunal was that HM accepted that the tone of her email had been unhelpful. You have no such comparable features to the claimant's case. All of those matters, the oppressive regime and the victimization and vindictiveness and so forth, they all plainly do give rise to a valid reason to start an investigation. The question is whether these supposedly comparable situations are sufficiently similar for the tribunal to place weight on them to enable it to reverse the burden of proof. My Lord.
Just going back to Martin for a moment, Mr. Justice Kavanagh, having quoted Shimon and other cases, says at paragraph 63 the question whether the situation of the claimant on the one hand and the proposed comparator, whether actual or evidential on the other, is a question of fact and degree. So when, on your submission, does a question of fact and degree shade into an error of law?
When a tribunal fails to give any indication that there has been any consideration of differences, particularly when submissions have been made setting out those differences, that is the point at which it is an error of law. When the tribunal has compounded that by failing to set out what the circumstances of the hypothetical comparator should be, then it is an error of law. Without doing both of those things, a tribunal, it is not clear that a tribunal has actually undertaken the exercise that it is supposed to undertake. Which, again, turning to Mr. Justice Kavanagh, and just, my Lord, the paragraph just preceding the one that you referred me to, at the end of at page 214, at the end of paragraph 62, actually I'm just hesitating because I think it's in fact paragraph 62 of Judge Taylor's judgment in Virgin Active that has been referred to, forgive me. It states, evidence of the treatment of a person whose circumstances materially differ to those of the claimant is inherently less persuasive than that of a person whose circumstances do not materially differ to those of the claimant. Well, as your ladyship said, that's perhaps a statement of the obvious. That distinction is not always sufficiently considered when applying the burden of proof provisions in section 136. I think that's exactly the situation that this tribunal falls into. And then if we look at paragraph 69 of Virgin, which is at the end of this citation within margin, so page 215, where, according to where a claimant compares his treatment with that of another person, important to consider whether that other person is an actual comparator or not. To do this, the Employment Tribunal must consider whether there are material differences between the claimant and the person with whom the claimant compares the treatment. The greater the differences between their situations, the less likely it is that the difference of treatment suggests discrimination. So if a tribunal doesn't mention difference at all, which is the case here, and doesn't appear to have considered any differences in relation to what are said to be comparable situations, one of which I suggest in relation to AE, it's got completely wrong in the first place, and in relation to another JR, where there's very little evidence even in its own findings that suggests that JR is a perpetrator rather than a complainer.
I was wondering whether JR in that paragraph is a typo for JD.
There's certainly some confusion at 22, because otherwise it's JR replying to JR's email. I mean, the situation between JR and JD, the evidence before the tribunal was that JR used her laptop at a training session, JD criticised her for it, JR then wrote an email in which a strongly worded email in which she complained about the fact that she had been criticised. It's an absolutely paradigm situation for having mediation between two people who have allowed their communications to rise to an unacceptable level, which is exactly what happened. And it happened with the claimant's agreement, because she was one of the managers for JR, was one of her team leaders. Why that is a comparable situation, or how that is a comparable situation with someone who's accused of oppressive behaviour and victimisation and vindictive behaviour, is certainly not clear from the Employment Tribunal's decision. Perhaps it is. Perhaps in some way there is some way in which it can be used, but the tribunal need to explore the differences as well as any similarities. It's not enough to say this person wasn't disciplined. People can be in all sorts of situations in the workplace. You could have stolen something, in which case you're obviously going to be disciplined. you can have written a snippy email in which you're unlikely to have been disciplined, and there's a whole gamut of material in between and otherwise. Some exploration of similarities and differences is required in relation to not only to actual comparators to see whether they are actual comparators or not, but also in relation to evidential comparators. I would suggest that the summary of the authorities by Mr. Justice Kavanagh makes it very clear that a tribunal should first distinguish between statutory and evidential comparators, and secondly, when looking at evidential comparators, explore differences and similarities. Those are simple points. They don't require any elaborate decision-making by an employment tribunal. But they require more than simply sticking a label on a situation and saying, these are comparable situations. And I know that what my learned friends say is that this is requiring a pernickety reading of the decision. But I'm not saying, what about the failure to mention difference number 8? What about this thing that was in a footnote to somebody's witness statement? They didn't mention that. What I'm saying is that there is no mention of difference. And there are a number of comparators. And if there had been an exploration of difference, then that would have led to a different conclusion, given the quite different sets of facts in relation to those comparisons. In relation to HM, which is the person for whom the tribunal have made the most findings of fact, the tribunal concluded in relation to HM at 70.2, I think it's only fair for me to specifically draw attention to this, that there was nothing equally serious against the claimant. So I accept that there is a comparison in relation to HM within that statement, but the nothing equally serious can only be, I suggest, a mistaken comparison of the situation not at the point at which allegations of oppressive behaviour and victimisation and so forth are made, which is the relevant time for this exercise, because it's about whether it was right to instigate an investigation. But it is an assessment made of the situation at the end of the investigation. Because as we know, at the end of the investigation, Ms. Tote, then dealing with it, determined that there was a need to address the claimant's conduct, yes, but that further formal action wasn't the best way of dealing with it. And reliance on HM alone does not appear to have been enough, even for the Employment Tribunal. Because at paragraph 70, back to page 120, the Employment Tribunal seemed to have shifted the burden of proof because of a number of comparable situations. My Lord, paragraph 70, 70,
yeah.
Page 120.
Yes.
Then turning to the Asian employees finding, we don't argue with the assertion in my learned friend's skeleton argument at paragraph 21, which is within the bundle at page 56, where they say, in a race discrimination claim by an Asian employee, clearly relevant and permissible and not dependent on identical circumstances, for an employment tribunal to take into account that the only other employees disciplined were Asian. As a starting point, I don't dispute that. However, if the tribunal are going to look at the treatment of other employees, they need to make an assessment of the extent to which the circumstances are similar to those of the claimant, if that's the comparison being made, or similar to those of HM, AE and JR, if that is the comparison being made, and to have made clear what is the comparison. Is it a comparison with the claimant situation? Is it the comparison with these other white employees? But the same problem arises in that the tribunal do not record that they looked at any similarities. They do not record that they looked at any differences. They were again given submissions in writing by Mr. Livingston of differences in relation to those people. The only one that was at the same level as the claimant was JSB. These matters are dealt with at paragraphs 55 and, forgive me, 53 and 54 in particular, page 117. JSB was a head of service, like the claimant. Now we've got a very small sample here. The tribunal don't refer to being cautious, for example, because they're dealing with a small number of people. If you have two heads of service and both are of the same ethnic group and both are disciplined, the tribunal seem to think that that is a matter which can sway the shifting of the burden of proof. But we do need to consider that if you change the ethnicity of just one of those people, the burden falls away completely. There are no details recorded by the tribunal.
Sorry, I don't follow that point.
Sorry,
You mean if you change the facts, then the conclusion may be different? Well, of course.
but the point that I'm making is just in relation to the sample size, my lord, that if you have only two people involved,
Yeah.
if one of them's white and one of them's Asian, then there doesn't seem to be any point to be drawn. If both of them are Asian,
That's a question of evidence and fact for the tribunal, isn't it?
yes, but no reference to any such consideration having
Well, I
been
understand that. I mean,
taken into account.
if I put your point in slightly different language, you say that in considering the construction of the hypothetical comparator, which is required in order to assess the difference in treatment, one material consideration is the similarities and differences between the hypothetical comparator and the evidential comparator. The Employment Tribunal didn't address that question, therefore they ignored a material consideration, therefore they made an error of law.
Yes. And in relation to these Asian employees, they don't set out any facts in relation to the situations that they were in.
Can I just ask a question about that, please?
Yes.
The claimant raised this point in her particulars of claim. She then made a data subject access request, the reply to which is recorded in paragraph 3 of the Employment Tribunal judgment. Sorry, the reasons for the judgment. What was the evidence that was before the Employment Tribunal about the other two Asian employees? Did the respondent produce any evidence?
I think there's a summary of.
When I say the respondent, I mean the council.
Yes. So, first of all, to take you to the respondent's submissions in relation to that matter, if we look at supplementary bundle 44, paragraph 26D, there's a summary of some of the information there. So page 44 in the supplementary bundle. So
So my tab 5 has got blank numbered pages, 37 to.
I think that's in the core bundle, milady.
You're looking at supplementary bundle, tab
Supplementary
11, respondents' written submissions.
Yes, paragraph 26D, beginning to the extent that information is known, Ms. Lake provided evidence that she led the disciplinary investigation into JSB, who was the only other head of service investigated during that period. She said that he acknowledged from the outset that his conduct had been inappropriate. And then the disciplinary investigations into KR were initially carried out by JSB, another BAME head of service, and secondly, commissioned by Ms. Lake and carried out by an independent head of service. I don't have, milady, the parts of the evidence within the bundle that specifically relate to that, but there is a summary. There is also reference to it in the grounds of resistance. I'm just having a look to see whether that goes beyond this summary. At page 135, paragraph 8. It doesn't really say anything in addition to those submissions by Mr. Lewison. I don't have anything else in the bundles that I can direct you to. But even that amount of information is not recorded by the tribunal.
So was there any evidence before the ET about the other person? I can't remember the acronym.
AR, is it, milady?
Was there any evidence?
I think again, just as recorded by Mr. Livingston at page 44 of the supplementary bundle, that the disciplinary investigation was initially carried out by JSB, and then Ms. Lake commissioned an independent investigation from another head of service.
Right, and that's all. That was all. And is that a summary of the evidence that Ms. Lake gave?
Yes, it's said to be at paragraph D there at page 44. Ms. Lake provided evidence that : A comparison can only be useful if the extent to which the circumstances are the same as the claimant's situation is taken into consideration. I mean, that's what Shamoon and Martin and Virgin Active all tell us. But to be fair to the Employment Tribunal, they don't make as much of this as the Employment Appeal Tribunal seems to have done, in which at paragraph 55 of the EAT judgment, at page 81 of your ladyship's bundle, the EAT elevates these two examples to what is referred to as comparable employees. And the EAT finds that those two examples are in similar circumstances to the white employees who were not disciplined. That's HM, AE, and JR. Now, there's no basis for making a finding like that, and of course the Employment Appeal Tribunal shouldn't be making any such findings. That is the function of the Employment Tribunal.
I don't think that's controversial.
It certainly shouldn't be controversial, but the EAT seems to have taken it upon itself to go further than the Employment Tribunal. The Employment Tribunal doesn't actually make a finding as to the degree of similarity, never mind list any differences. So, my Lord, those are my submissions in relation to ground 1, unless there was anything in addition. Turning to ground 3, which is that the Appeal Tribunal and the Employment Tribunal took the wrong approach to the respondent's non-discriminatory explanation for the treatment. So as we've seen at paragraph 76, before even turning to the respondent's explanations, the tribunal had expressed its view that we are satisfied that race played a part, which is a good starting point for an examination of whether reasons given by an employer or an individual in this case were non-discriminatory. Then at pages 122 to 123 of the bundle, in the judgment at paragraph 79 to 80, when the Employment Tribunal considered the non-discriminatory explanations, I suggest that in relation to many of them, what the tribunal failed to do was to consider the correct question, which is this a genuine reason, which is a non-discriminatory explanation? And instead the tribunal almost treat it as if it's an unfair dismissal type case in which they're looking at whether they thought that it was a reasonable approach to have been taken by Ms. Laing. Now they do set the test out correctly at paragraph 80, but the analysis at 79.1, certainly to 79.5, I suggest makes it clear that they didn't apply the test. If we look at them very briefly, one by one, we have at 79.1, the tribunal concluding that the argument is without substance because Ms. Lake could have made informal inquiries. It disagrees that a disciplinary investigation was needed. That isn't the question that the tribunal should have been asking themselves. What they needed to do was to consider whether Ms. Lake genuinely believed that disciplinary procedures were appropriate. At 79.2, the tribunal concludes that it was her decision and that she can't hide behind human resources. But it doesn't engage with whether human resources agreeing with Ms. Lake makes it less likely that the reason for her action was the claimant's race. At 79.3, the tribunal concludes that a disciplinary process being preferable to a grievance process wasn't offered as a rationale at the time and has no merit. Well, the question isn't whether the disciplinary process was appropriate. The Employment Tribunal clearly considered that it wasn't appropriate. But the question at this stage is whether this is the actual reason, whether this was Ms. Lake's reason.
Well, the fact that it was never offered as a rationale at the time is quite a powerful indication that it wasn't.
That is a conclusion that could be drawn from an earlier finding, but you can't stop at the point at which you say that that a disciplinary process wasn't preferable to a grievance process. That's a view taken by a tribunal after the event, looking at what has happened.
It depends how you interpret the phrase "has no merit." Given that they correctly directed themselves on the test of paragraph 80, as you quite rightly say, has no merit can mean it wasn't a genuine reason.
But it can also mean, my lord, and I think that the previous paragraph suggests that this is the approach that was being taken, is that the tribunal thinks that it was the wrong approach. And the wrong approach isn't the answer to this particular query. Now, in relation to the next one.
Cogency, I mean, we might be splitting hairs. It's not really credibility findings so much as the cogency findings, whether it just stacks up as an explanation. Not really whether it was wrong or right, or whether somebody else would have done something different. They're looking at the reasons put forward and saying, are those coherent? Is that cogent? Is that, I suppose it is a credibility finding in the end, isn't it?
Well, Melanie, I'd suggest that the way that it's phrased suggests that they're looking at it more as a tribunal would look at an unfair dismissal type situation, which is, was this the right thing to do? Was this the wise thing to do? Could something else have been done? Would we have done something else? Those are all perhaps starting points for a tribunal to go on and make other conclusions. But what they needed to focus on as the ultimate questions in relation to all of these 7 explanations, they do actually do it in the last couple, is whether it was a genuine reason.
I mean, 79.6 seems to be an assessment that this wasn't really a genuine reason.
Yes, so point 6 and point 7 I accept in relation to both of them. I mean, point 7 is I think, the most obvious.
Same with 4.
And 79.6, I think, given the benevolent reading that is required of tribunal decisions, I don't make any argument that that isn't capable of being read as a decision in relation to credibility. I think 79.4 is somewhat more nuanced because the focus seems to be on whether it was fair or reasonable to have taken into account.
79.4 is this is an explanation that's made up in the course of the cross-examination.
Well, I'm not going to argue in relation to 79.4, but I think that certainly 79.7 is the most obvious one, and so there are examples of the tribunal doing it correctly within this list. But in relation to 1, 2, and 3, I suggest that they are looking at the wrong thing, and that has infected the way in which they look at it. So what the learned friends say is that the tribunal assessed the credibility of each of the reasons put forward. And for the first three, certainly, I suggest that there being no mention of credibility, that isn't what the tribunal were doing.
Yeah.
Now, the Employment Appeal Tribunal bluntly responded to this point by saying that it's a dressed up perversity ground. I think that that's not a fair way of describing it. This is page 98 of the bundle, paragraph 95. It was contended to be an error of law, and what was required of the Employment Appeal Tribunal, I would suggest, is to conclude what question does the Employment Tribunal need to ask itself, rather than, as the Appeal Tribunal failed to do, to fail to engage with the point and simply say, well, the tribunal considered whether there was a non-discriminatory reason and found that there wasn't. Although reasons from an employment tribunal do not need to be detailed or elaborate, they do need to go further than simply saying there wasn't a non-discriminatory reason.
Do you say the reasons at 1, 2 and 3 were good reasons if they've been phrased differently, or do you say that they were not capable of being reasons that went to cogency and credibility of the excuse put forward?
I think that they're not assessments of credibility, and that is the problem with them.
Because speaking of some, I don't live in the world that you live in, but speaking of myself, they seem to me to be quite powerful, quite sensible reasons.
They
Those
may.
are things that you're entitled to say if you're trying to decide whether the explanation put forward is a credible one or was genuine. What's the language?
Aren't they in effect saying that the section 9.3 isn't credible? They say it was never offered as a rationale at the time, and in any event has no merit. Somewhat bizarre to suggest that because no one had lodged a grievance, this somehow made a disciplinary process appropriate.
But
That is credible.
someone might be wrong or even bizarre, but it might be their reason. The tribunal needs to have gone on. I'm not suggesting that the things that they have found here could not be part of an overall assessment. They need to have gone on and said, in relation to what Ms. Lake has told us, we do not accept that it is credible, in the way that they are clearly able to do, because at 79.7, which is the clearest example, they make a statement if she had genuinely believed something, which I don't argue with the fact that that means that they found that she didn't genuinely believe it. We don't have similar language used in relation to the
So
other
if they
points
talked
provided.
about, if they tied 1 and 2 to the concept of genuine belief, you wouldn't have a point. Is that right? You would accept that those were legitimate points to make?
Well, if they had said, we find that she didn't genuinely believe these things, then I wouldn't have this argument. But because they didn't, and because of the way in which they do look at it, I suggest that they weren't looking at it from the correct point of view.
You say you accepted in paragraph 80 they corrected themselves correctly. So the question they asked themselves is there a non-discriminatory explanation for the treatment? And they went through the explanations and basically said they don't stack up. What's wrong with that?
Because in 1, 2 and 3, what they think is an answer to that question is that they don't think that those were good reasons. And if that is what they did, that isn't it isn't the way that they should have approached it, and it's not the question that they should have been answering.
But one is pretty obvious. I mean, actually they are, I think, possibly saying that they're rejecting Miss Lake's evidence, aren't they? Because it's an obvious point to make. If what you want to do is speak to witnesses, you don't need an investigation to speak to the witnesses. You can go and speak to whoever you want to.
Well, I mean, on the facts, if someone is accused of operating an oppressive regime amongst their workforce, it isn't at all obvious that you can do anything other than investigate the matter by going and having someone independently speak to all of these people, and
I
indeed.
take a step back and ask whether the person who's making the accusation of an oppressive regime has slightly lost the plot. The phrase oppressive regime conjures up all sorts of things which can't possibly be going on in this workplace.
Well, I mean, SCC does, and it's set out in the supplementary bundle between pages 3 and 7. She does give chapter and verse as to why she considered that there was an oppressive regime. So there was evidence there about her observing one of the claimant's direct reports at the bottom of page 4, looking extremely uneasy and scared. That SCC says that she became alerted that she was frightened. At the top of page 5, that SCC says, have you been told not to help me? And then, oh my God, you have, haven't you? You've been told not to help us, don't worry about it. Going on to say that she said it was an oppressive practice. There is detail there. It wasn't as if Ms. Lake based her decision on a passing comment in the corridor or one line in a late night email or something of that nature. This is someone who had put together a statement of her concerns on the 15th of December 2020 from the date at the top of page 3, and having reflected on them, had set out all of this.
But the ET's comment about SCC, paragraph 26, SCC submitted a statement identifying a number of incidents. These were, it has to be said, all at fairly low level. And then they give an example. Isn't ET entitled to reach that view?
I mean, it's a surprising phrase to use in relation to the matters that SCC sets out, but it is the Employment Tribunal that is the body that determines the factual matrix.
I think we can infer from that that the EC thought that SCC's language was a bit florid.
But the ET's assessment of SCC's evidence isn't the important one. It is for the ET to consider whether Ms. Lake was genuine when she said that it was firstly SCC's materials, and then secondly all of the matters brought to Ms. Lake's attention by AE. And there we have a series of emails from page 9 through to page 13, in which AE, that's someone else, in relation to the claimant, makes reference to intimidating and unhelpful behaviour, victimisation, victimisation at the top of page 11, and over at page 12, unhelpful and unnecessary interactions, vindictive and unprofessional, saying that because of the victimisation of one individual, SR, that he intends to leave the authority. And this is within a resignation email from AE to Ms. Lake, in which the primary reasons given are the behaviour of the claimant and the team that she manages.
But the ET said that they didn't think anybody thought that AE's threat to resign was genuine.
And again, a surprising conclusion on reading pages 12 and 13, which I would invite this court to do in the course of making its decision. But it's not the Employment Tribunal's determination of whether it would have launched an investigation, which is key. It is whether Ms. Lake, on receipt of this type of information, genuinely believed that it was a suitable thing to do to start a disciplinary investigation. We're only talking about an investigation. Of course, it was an investigation that after the claimant had been spoken to, after other people had been spoken to, resulted in a conclusion that whilst the claimant's conduct needed some addressing, it wasn't suitable to be taken on to a disciplinary hearing. So in that sense, the investigation process was operated as it should do. But you can't start at the end and work back. So a different aspect of this ground 3 is that one of the consequences of the tribunal's failure to apply the burden of proof provisions separately in relation to each allegation of less favourable treatment is that it didn't take into account the respondent's explanation for some of the treatment. So at paragraph 79, that's all about the reason for the investigation being commenced. In the written submissions from Mr. Livingston, there was a separate account given of the reasons for each of the separate alleged detriments, including the decision to transfer the claimant to a different area. So that's a different decision for which different rationale was put forward, and the decision to have meetings with the claimant at which she could put forward her side of things. In relation to issue 2, the reason for the transfer, what was said, and it's in the supplementary bundle at page 19, in paragraphs 63 to 64 of the submissions, that because the claimant was accused of instilling fear in her staff members, Ms. Lake thought, well, we'll move her to investigate whether it's true so that these people can speak openly and to ensure that she's not in a situation that could give rise to any further concerns. Even the claimant in oral evidence said that she had no reason to doubt that explanation by Ms. Lake. It wasn't suggested to Ms. Lake in cross-examination that her reason for the transfer, the given reason for the transfer, was untrue. It wasn't suggested to her that it was false. And the tribunal don't come to any determination in relation to that. My learned friends, in their skeleton at paragraph 31, they try to fill in the gaps in the Employment Tribunal's reasoning. So page reference there is page 59 of the bundle. They suggest that the word suspend, which is the word used by the tribunal, paragraphs 35 and 81 of the decision, and transfer, which is what actually happened, are the same thing, which they're not. The tribunal's finding at 79.1 about informal inquiries is about whether a formal investigation should be investigated. It's not about whether such an investigation having been instigated, the claimant was treated less favourably because of race by being transferred. If that's a separate allegation, it deserved a separate consideration of the reason given. And in relation to the meetings, and I think that we have covered this in some of the responses earlier, there's reasons set out at paragraph 77 to 79 of the respondent's closing submissions, pages 55 to 56 of the supplementary bundle. It's said that at the first meeting took place because Ms. Lake decided that a number of allegations needed to be explored with the claimant. That is a natural part of any investigation process. And for the second meeting, Ms. Lake and subsequently Ms. Tote had further issues that they wanted to explore with the claimant, the first meeting having overrun. Those are cogent reasons. They sound as if they're the sort of reasons that would be put forward by any employer in any disciplinary investigation process, but yet the tribunal don't consider them separately when dealing with this part of the exercise. The learned friends in their skeleton argument in tackling this matter at paragraph 33, page 59, merely go back again to the explanation for commencing the disciplinary process in the first place. They make reference to paragraphs 85 and 86 of the tribunal's decision, but there's no analysis by the tribunal of the respondent's explanation. All that's said is, for the reasons given above. But there are no reasons given above that relate to these additional matters. Those are my submissions in relation to ground 3, unless there was anything else. Ground 4 overlaps with ground 3 to an extent, and it is that the tribunal and the appeal tribunal took the wrong approach to the claim about the decision to invite the claimant to meetings. So it's not only in relation to that second part, which I've just covered, but also in finding that that decision was a separate, or those decisions in relation to the meetings in February and April were separate acts of race discrimination. The tribunal have effectively found that they didn't state this to be so. Perhaps if they had done, it would have been clear to them this wasn't a finding that they should have made. They've effectively found that inviting a person whose conduct is being investigated to 2 meetings to discuss her conduct is less favourable treatment because of race than would have been afforded to someone else whose conduct was being investigated. The only proper comparator for that allegation could be, or must be, someone else whose conduct was being investigated. There are no findings, there's no evidence that white employees who were being investigated weren't invited to meetings. It would be extraordinary if anyone being investigated wasn't invited to a meeting to discuss these matters.
But it might be suggested that's an artificial series of distinctions, and the real point, I think this goes back to a question my lady asked earlier on. The real point is that the ET found that there was no substance in the disciplinary decision to go for a disciplinary process, and calling somebody to meetings to discuss something that's of no, which there is no basis, is a detriment, and it's linked to the decision to start the disciplinary process in the first place.
Lady, your ladyship uses the word linked. Was the invitation to the meeting in February because of race? Was it less favourable treatment than would be afforded to someone else in similar circumstances? Those are the questions that the tribunal had to ask. There are other questions which might be asked which relate to the impact of the original decision to start the disciplinary process. But those are all matters which might go to remedy or compensation about the things that happened as a result of that. But if one thing is a consequence of an act of discrimination, that doesn't make it a separate act of discrimination in itself. And we say not only is it a perverse conclusion on the basis of the evidence before the tribunal, on the basis of the lack of findings by the tribunal about this matter, but it's also insufficiently reasoned. The reasons given above, as I've said, do not tell us why these things happened. And the second of those meetings was a meeting conducted by Ms. Tote, who isn't accused.
Isn't that the third meeting?
No, the third meeting which they found wasn't discriminatory, which was the meeting,
Oh, I see what
the
you're saying.
outcome meeting. But the second one, my lady, on the 22nd of April, was a meeting after Ms. Tote had been had replaced Ms. Lake as the investigator. And it was a decision to hold a meeting by Ms. Tote after Ms. Tote had got to grips with much of the material that she had been given in relation to the investigation.
Well, you say Miss Tote decided it, but the AT says the decision was really that of Miss Lake.
Yes, I mean, the tribunal doesn't explain why it says that, but
Well, I think, isn't there something along the lines of Ms. Lake had arranged for a second meeting, it was postponed because the claimant was ill, and the meeting that Ms. Tote had was the adjourned second meeting that had been arranged by Ms. Lake.
yes.
Isn't that the explanation?
Yes, I think that's certainly the course of events, but there's nothing in that sequence of events that suggests that that was less favourable treatment than would have been afforded to someone else whose first meeting hadn't covered all the issues and for whom there needed to be another meeting at which, and the fact that someone else, I mean, if I'm wrong about that, the fact that someone else came in and continued on with the meeting suggests that it was a meeting that was necessary in order to garner the claimant's side to the matters that were being examined. and which, as we know, resulted in Ms. Tote deciding that the matter wouldn't go any further, which was communicated at the third meeting. That these are things that the tribunal should have gone through and didn't. And there's no examination, as I've already said, in relation to ground 3, of the submission made about the non-discriminatory explanation for that conduct. What my learned friends say about this is at paragraph 34 of their skeleton argument, page 60 of the bundle, which is that the meetings were an integral part of the decision to commence the disciplinary process. If they are an integral part or a consequence of the decision to commence the disciplinary process, that isn't a separate act of race discrimination.
Yeah.
My learned friends go on to say at paragraph 35 in relation to this point that there is no need for the Employment Tribunal to refer to the two-stage process in relation to each and every complaint, and we do not have any argument with that. There is clear authority to that effect. But this tribunal indicated that it was taking that approach. That, I say, we can read from paragraph 65, which we looked at earlier, and accepting on our part, as we do, that they don't have to refer to the two-stage process doesn't mean that they don't have to be clearly following the two-stage process. And if a tribunal is following it, it has to be tolerably clear that it is doing so, and that, I suggest, is not the case here, and especially illustrated by issue 4. So quickly, in response to the general points at the end of my learned friend's skeleton, pages 60 to 61, I mean, of course, they say that we are adopting a hypercritical fine-tooth comb approach. That's what I always say when I'm on that side of the debate. But that isn't the case here. The respondent doesn't understand why it lost this case. The learned friend's short summary of the Employment Tribunal's reasoning at the end of their skeleton does demonstrate some of the problems with the tribunal's reasoning. At paragraph 38, Roman 1, at the end of the skeleton, the learned friends elevate the conduct of HM, AE, and JR to multiple instances of more serious conduct on the part of white employees. Now, as we've seen in relation to AE, there's no such conduct. In relation to JR, it's difficult to see how what is recorded by the tribunal could possibly be more serious on the tribunal's findings of fact. In relation to HM, I accept that there's more of a point to be made, but it's the supposed number of comparable situations that swayed the tribunal according to the tribunal's reasons at paragraph 70. When at most we have HM being treated differently to the claimant in quite different circumstances, none of that difference having been explored, it would seem, by the tribunal. My own friends go on to say that the only comparable people subjected to disciplinary proceedings were Asian, but the tribunal didn't make sufficient findings that these other people were comparable. And I've already made the submission about the differences in different types of disciplinary matters, ranging from theft to communication problems. Paragraph 38, Roman 2, is also problematic. There was no victimization claim before this tribunal. That was made clear in paragraph 1. It can't enter by the back door. The Employment Appeals Tribunal, at page 92, paragraph 75, found that this reference was of little, if any, assistance. And then the disclosure stance, which your lordship will hear more of from Mr. Livingston now. That stance taken by people other than Ms. Lake throws no light on the decisions made primarily by Ms. Lake, primarily on the 12th of January 2021. Those are my submissions in relation to ground 4. Mr. Livingston's now going to address you in relation to ground 2, unless there was anything else on any of those grounds on which I can assist the.
Thank you very much, Mr. Brown.
Your Lordships and Lordship. So this issue is about the approach that should be taken by employment tribunals when considering whether to draw adverse inferences from a disclosure failure in the context of a discrimination claim. So at the outset, for the avoidance of doubt, there's no dispute that employment tribunals can draw adverse inferences in some cases, but we say this is not one of those cases, and that there's at least 2 further steps that need to be followed that we are to follow in this case. So firstly, if I just set a brief factual background in relation to the disclosure points, there's 2 separate types of reported disclosure failings in this case. The first type relates to the recordings of interviews carried out during the investigation. These were interviews that were carried out in late January, early February 2021. And reminding ourselves that the decision to commence the investigation obviously preceded that on the 12th of January. Now, in relation to these interviews, the respondents' solicitors were of the view that these were not relevant to the issues because they postdated the decision to instigate the disciplinary.
Are you waiving privilege about their advice?
Yes. I was about to ask.
That's a decision that was communicated. There's an email from the respondents' solicitors setting out.
That's a bundle.
Yeah, it's in the supplementary bundle.
All right.
Setting out their perspective on that. And I'll come on to why this is an obviously legal decision rather than a factual decision. And within that email, which I can take your Ladyship's and Lordship to if it's helpful, the respondent solicitors set out that they'd asked on 5 occasions why the claimant's side thought these were relevant and simply been told that they were plainly disclosable. And the respondent solicitors said that if they received a clear explanation or a specific disclosure application, that they'd reconsider the position at that stage. So that's a supplementary bundle 14 and 15 for your reference. So that's one type, is the interview recordings. The second type is notes made by Miss Lake and by Miss Tolt during the investigation, both handwritten notes and notes of questions to ask. Now, in relation to these, in relation to the recordings, it's clear that they existed. The respondent's position was they weren't relevant. They disagreed, the tribunal disagreed. In relation to these notes, there's no finding that these actually existed at the time of the Employment Tribunal hearing or at the time of disclosure. So we have Miss Lake saying that she'd taken handwritten jotters, that she hadn't provided them to anyone because she thought the recordings themselves were the important matter of what was contained within the interviews. And she said she wasn't sure if she still had the notes of the questions she was going to ask. And then you have Miss Tolt, who also said that she took notes of interviews, and she said that she'd shredded them after 6 months because she decided that there was no case to answer and no one had asked her to keep them. And again, for your reference, that's contained within the extract of evidence, it's supplementary bundle 57 to 58.
But the ET said it was obvious that these ought to have been kept.
Yes.
Paragraph 78.
Yes. So we say that is the first. That's obviously the first step that the Employment Tribunal needs to ask. It needs to ask whether there was an unreasonable failure to disclose. I don't dispute that finding. That's a finding that the tribunal is entitled to reach, and as your Lordship says, it says that 77, 78. But we say that having decided that, what the tribunal did is automatically lead to the drawing of adverse inferences without the necessary steps in between.
I'm sorry, I think that just doesn't work at all. There is an equal presumption, if not a stronger presumption, against somebody who destroys documents which are relevant to contemplated litigation.
Yes, again, that is an inference that you can draw, but only if you link the failure to disclose or the failure to retain to the discriminatory act. So, for example, and I'll go through what I say should have been said. For example, Miss Tote not keeping her handwritten notes of interviews after she took over from Miss Lake. In what way does that shed light on Miss Lake's decision to instigate the decision?
Well,
We don't know.
Well, we don't know, but
Well,
it could potentially shed light because one question is what, if anything, changed between the position where Ms. Lake thought there was something to investigate and the position where Ms. Tote thought there was no case to answer? And the answer might lie in what she was told in the interviews.
Miss Tote gave evidence on her reasons for discontinuing the investigation, for finding that there was no case to answer. And in order, I say, to draw an adverse inference in that example, the tribunal would need to decide that Miss Tote essentially destroyed her evidence or was not told to retain her evidence in order to cover up for Miss Lake's initial decision. That's the step that you need to take in order to draw an adverse inference.
Why can't you just, because they tell you, I mean 77 is pretty clear in saying this was relevant evidence. I don't think you challenge this.
No.
Because it was on the basis of that evidence that Tote decided there was no substance in the allegations. I mean, obviously it's really relevant evidence because the whole point of this case is the claimant saying I was facing a trumped-up investigation for which there was no good basis, right? So it's obviously relevant evidence. I mean, why do you need to thread a needle like this? Why can't you just say it's an open ET to draw an adverse inference if they think it's appropriate and fair to do so?
Because the case, for example, of De Silva, which is an EAT case, I appreciate Mr. Justice Underhill says that it's not enough to stop at that stage, that disclosure failures are only relevant to the extent that they potentially shed light on the actual.
But they've told you exactly why it sheds light at para 77. It's all part of the same picture, isn't it? Because that evidence was really material to why there'd been an investigation in the first place, which was exactly the point that Mrs. Parmar was running.
Well, this was a decision about the relevance of documents, so that was the dispute. That it wasn't a situation where Miss Lake said these recordings didn't exist and didn't provide them to anyone, for example. Miss Lake provides them to Miss Tote, provides them to the respondents and legal team. And so we say what you actually have in relation to the recordings is a decision about relevance, which the tribunal disagrees with the respondent's position on. But the question is whether that decision about relevance, whether that view taken about relevance is enough to shed light on, or potentially shed light on, the reason for instigating the decision. And we say this is not a situation where Miss Lake's making the decision to hide these recordings or anything like that. Miss Lake is the alleged discriminator, and we say there's not enough from that decision about relevance to say that she's the one that suggests that she discriminated.
Hasn't the Supreme Court said that tribunals should be free to draw inferences or not without looking up law books?
Possibly, Your Lordship, but I'm not saying this required a looking up of a law book. I'm saying this required 3 simple steps. Was it an unreasonable failure? They said yes in this case, I don't dispute that. Second of all, does it shed light, or potentially shed light, on the thought process of the alleged discriminator? So does Miss Tote not keeping her notes potentially shed light on Miss Lake's motivations? And then the third thing is to consider the reasons why there were disclosure failures or retention failures. So for example, in relation to the recordings, you have a disclosure failure because of a different view about relevance. In relation to the notes, you have that Miss Tote said she got rid of them because that was the respondent's policy, to do so after 6 months she wasn't told to keep them. And those are all, I say, relevant considerations as to whether you should, in fact, draw adverse inferences. So, under that second step about whether you, whether it sheds light, whether the failure is capable of constituting evidence from which you can infer discrimination, part of that is whose failure is it? So I say, for example, if this had been a failure by Miss Lake to disclose the interviews, that would weigh in favour of drawing an adverse inference. The fact that it wasn't weighs against it. And similarly, in relation to the destruction of, or the not keeping of notes by Miss Tote, that is a combination of a decision by her and a decision according to the respondent's policy, which is to get rid of things after 6 months.
I see the way you're atomising it, Mr. Lewison, but isn't the legal position that the respondent to the claim is the council? The council is liable for the acts of discrimination by its employees. And it looks as though the legal advice was coming from an in-house solicitor. So it's all within the same entity, isn't it?
I think that the difficulty is, or the answer to that is really that because you're looking at a direct discrimination claim where a tribunal is finding that this person, Ms. Laing in this case, discriminated because of race, you have to actually look beyond that and look at the mental processes of the decision taker. So that's what Mr. Justice Underhill says in
Well, that may be, but if it's the council's policy that documents should be destroyed and the respondent to the claim is the council, why is that not relevant to the question of whether an adverse inference should be drawn?
Well, because I say that the fact that that was the respondent's policy and the fact that Ms. Tote actually according to that sheds absolutely no light on why Ms. Lake.
Well, we don't know because we don't know what's in the
I don't know
notes.
what's in the document.
There's not even any potential light that it sheds. It's hard to envisage what potential light the council having that policy for however long it had that policy, and Ms. Tote, who's not an alleged discriminator, acting according to that policy. One might ask what possible inference could be drawn from that.
Because Toad investigated, she did the investigation, and it would have been really interesting to know what she'd found out in the course of that investigation and why she pulled the plug on it. Would have been really, really important to know that, because that does cast a light on the decision to initiate the investigation in the first place. It may not answer every question, but it's obviously relevant, isn't it?
Well, absolutely. Ms. Tote's account of why she discontinued the investigation is relevant, and she gave evidence about that.
And what she found and what people said.
Yeah, she
That's relevant.
gave evidence on that. But this is not about whether that goes to Miss Lake's decision. It's about whether the act of or the omission of failing to retain.
It's all the same. It's all the same package. I mean, atomising is a good word, and I've written it down. But it's exactly. You can't. The fact is that evidence wasn't before the ET, and they found that very frustrating, and one can understand why.
Well, so for example, with regard to the handwritten notes, so these are as relationships and particularly Justice Laing will be used to. It is very common for in disciplinary investigations or grievance investigations people to take handwritten notes alongside recordings of interviews, for example. But for those handwritten notes not to be in a bundle because they don't add anything. So the question is whether in this case, the not having Miss Tote's handwritten notes, when every interview was recorded and when Miss Tote gave evidence about her reasons and isn't accused of discrimination, of course.
Because we don't know, but her notes might have contained her observations about it. I mean, we just don't know because the notes aren't there. But isn't the tribunal entitled to say, well, we haven't got the notes, and they might have given us a contemporaneous insight into what she made of those.
Well, that is the first. That's the first step. That's whether they're potentially relevant and whether the disclosure first. That's fine. But the question is whether not having them in the bundle is something which makes you think Miss Tote or the respondent in developing this policy is doing something to hide things from the Employment Tribunal, or is doing something to cover up the reason. It's not about whether the notes could be relevant, it's about whether the decision not to produce them or not to retain them is relevant. We say that's the difference. You're looking at whether the decision to not disclose or to not retain is something which makes the tribunal think there's something fishy going on here.
Yeah.
And we say that is not a step which the tribunal asked itself at all in this case. The tribunal would have been entitled, I say, after paragraphs 77 and 78, to go on to say those were in our view relevant, and in our view the decision not to disclose, the decision not to retain is suspect, or we're not convinced by the reasons for it, and so we think that potentially would potentially have shed light on the actions or the mental process of the discriminator. And we say that just didn't happen here. The tribunal didn't take anything beyond, we think these are potentially relevant, and so we draw adverse inferences. And that's exactly what Mr. Justice Underhill warned against in De Silva. He said that we shouldn't just have a finding that something relevant hasn't been disclosed, but there's been a failure, and automatically that leads to a presumption of discrimination.
Do you want to refer us to the exact passage you're relying on?
Yes. So De Silva is the authorities bundle, tab 4. And it's the first relevant bit, I think, is at page 88 of the authorities bundle. So if you start at paragraph 37, which actually isn't sidelined, page 88, about halfway down, the EAT, Mr. Sandel states there's no evidence before the tribunal which could have made a link between, on the one hand, the decision which led to the design of the computer systems and the decisions about provision of legal systems. It's important to emphasise that failures of the kind complained of are only relevant to the extent that they potentially shed light on the actual discrimination complained of, and thus necessarily on the mental process of the decision taker. And then at paragraph 38 goes on to say, we have observed a tendency in discrimination cases for respondents' failures in answering a questionnaire or otherwise in providing information or documents to be relied on by claimants, and even sometimes by tribunals, as automatically raising a presumption of discrimination. That is not the correct approach. And it goes on to say, although failures of this kind are matters from which an inference can be drawn, and it's only in appropriate cases. It is necessary in each case to consider whether, in the particular circumstances of that case, the failure in question is capable of constituting evidence supporting the inference that the respondent acted discriminatorily in manner alleged. If so, whether in light of the explanation supplied, it does in fact justify that inference. There will be many cases where it should be clear from the start, or soon become evident, that any alleged failure of this kind, however reprehensible, can have no bearing on the reason why the respondent did the act, which is in cases of direct discrimination what the tribunal has to decide. So
This is, I mean, it surely is a fact-sensitive question, and the facts of this case are very different from the facts of this case, aren't they?
yes, and there's no dispute that the tribunal could have gone on to consider whether there was links between 3 alleged disclosure failures or retention failures and the 4 acts of discrimination which it upheld. But you need to draw that link. There needs to be a line where the view is that the decision or the view taken that the document, that the interviews weren't relevant, makes us think that Miss Lake, or makes us think that Miss Lake might have discriminated because of race, or that Miss Totes not keeping her notes makes us think that Miss Lake might have discriminated. That line, I say, is the crucial thing that the Employment Tribunal needs to follow. And I appreciate your ladyship's view, point that it's all part of the same thing. I say that what this says is there are 3 steps to be followed, and the tribunal quite obviously only did the first one of saying it took the view these were relevant documents.
The complaint in De Silva was that the tribunal didn't draw an inference.
Yeah. Your Lordship, that's right, but I think that what Lordship, what
And Mr. Justice Underhill's observations must be read in the light of the the ground of appeal he was considering.
Yes, although I think I would say that the comment in paragraph 38 is clearly aimed towards a broader situation. And particularly where it says disclosure failures or any alleged failures, however reprehensible, because it's not suggesting this was a case where there was a reprehensible disclosure. However reprehensible the failure, it's only a question of whether it has a bearing on why the respondent did the act complained of. And we say that's just not the tribunal didn't follow that process. And we say that the starkest example of that, because the tribunal draws adverse inferences, as I said, from the two categories of disclosure failure. The starkest example I see is, although the tribunal doesn't say it implicitly drawing an inference from Miss Holt's failure to retain notes to make it think that Miss Lake acted in a certain way. So that's just not an inference that's open to it. And what this is where the tribunal used its disagreement or displeasure with litigation decisions to draw an inference of discrimination rather than considering whether that line is there. And relations and logic, unless I can insist.
Thank you very much.
And those are the submissions on behalf of the.
Yes. All right. Well, we'll just go outside for a minute or two. Don't leave the courtroom, please. We'll be back shortly. Mr. Palasar, we'd like to hear you on ground one. We needn't trouble you with any of the other grounds.
I'm most grateful, my lords and my ladies. Can I start with an apology, indeed 1,000 apologies. I think it was Lord Donaldson who said in UCAT that it would be 1,000 pities if employment tribunal decisions were subjected to a minute analysis. So I apologise for the 1,000 pities I'm about to evoke by doing that sort of granular exercise that I fear this appeal requires. I say, simply put, my lord, my ladies, that this is a tribunal carrying out its task in the way envisaged by DPP and Greenberg in a compendious and workmanlike manner that has been subjected to an overly detailed analysis. It is very clear, my lord, my ladies, when one reads the judgment that the contention that the tribunal had no regard, which is the ground of appeal, to the question of comparison, or insufficient regard, simply does not bear even the lightest of scrutiny. I will show, or I say it's very clear, my lord and my ladies, on reading the judgment, that they had the question of comparison at the forefront of their minds. They then carried out a careful staged comparison in the following stages. Firstly, making findings of fact in relation to each of the comparators and in relation to the claimant, as to the allegations against them both and the treatment of that. They then, in the next stage, assess the relative gravity of both the allegations and the response. And then lastly, they compare the treatment of the claimant with the comparators, arriving at clear conclusions. And what the appellants seek to do by a fine sausage slicing, if you'll excuse the analogy of the judgment, is under the fig leaf of an error of law to take the decisions that were the purview of the tribunal, that comparison of evidential comparators, and say that that is an error of law. If I may start with the question being at the forefront of the mind of the tribunal. The Employment Tribunal set that out 3 times. Firstly, when setting out the issues, I may ask you to turn to page 118 of the bundle, where the issues are set out. And it may be said, it's a trite point to say the tribunal has identified this issue, but in Greenberg, this court said that where a tribunal has set out the issues, it is not likely to be assumed that they have not applied the matters and the law. And it is page 118, paragraph 55. Firstly, when setting out the issues, the tribunal set out, in relation to each of the above, the detriments, did the respondent treat the claimant less favourably than it treated or would have treated a comparator? So far, so standard, one might say. However, they do so again, my lord, my ladies, at paragraph 59 on page 118. This time, when setting out the law, they set out at paragraph 59, section 13, stating section 13 refers to treating a person less favourably, which implies a comparison of treatment. Again, one might say, well, it is relatively standard to set out the agreed issues and set out section 13 in a direct discrimination claim.
And then they set out section 23.
Section 23, indeed, lady. But that comparison and the care to be taken with comparison is at the forefront of their mind. As a particular issue in this case is clear, if one turns to page 120, their conclusions begin at page 120 and go on for 5 pages thereafter. But it is notable that at the start of those conclusions, they state at paragraph 68, in relation to this case, the real contentious areas in this case are of appropriate comparison. Whether the burden of proof passes to the respondent to show a non-discriminatory reason for the treatment, and if so, whether the burden has been discharged. The test was set out correctly, not once but twice, and they identified that as an area for particular care in this case. So in response to the assertion that the ET had no regard to comparison, I say that is plainly and obviously not so, even without any sort of charity, as it is regarded, I say, proper due regard to the role of the Employment Tribunal in carrying out its task in a compendious way. Having set out those issues, the Employment Tribunal then carry on to carry out that comparison. There are 3 evidential comparators. I'm afraid I've had a word blindness in relation to acronyms, but I will try and convert the names into acronyms again. HM is the first instance, the head of service swearing in May 2018. Then HM again, seeking at short notice by email to transfer her work to that of the claimants department, again in 2018. And then Joanna Roadnight, I'm so sorry, JR, according to JD, engaging in conduct that she described as being humiliating and denigrating. And in relation to each of those 3 comparators, the Employment Tribunal go through a process. They make findings of fact as to what occurred, they assess the gravity of both the offence and the response, and they compare that with the claimant. And I say, my lords and my ladies, that this, in any event, is a classic question of fact as to the weight of the evidence and circumstances. That is the proper purview of the tribunal. And Hewitt and Grampian isn't in the bundle, but His Honour Judge Tayler refers to it at page 86 of the bundle at paragraph 63 and paraphrases the passage where in that case it said whether the claimant and comparators, actual or hypothetical, are comparable is a question of fact and degree, and that is evident also from Lord Hope at paragraph 20 and 26, that judgment. That comparison, my lord, my ladies, I say, is the proper function of the Employment Tribunal. When weighing evidential comparators, it is an exercise to be carried out, and that is why the Employment Tribunal, the industrial jury, is so constituted, not on paper, not on abstract, not in abstract, but because of the subtlety of discrimination and the difficulty of detecting it, to be done as it was done here, over 5 days, with the live evidence of the key players, or insofar as the respondent chose to call them. You may feel there was a paucity of witnesses, cross-examination, and 680 pages of document, although again you may think there's a notable absence of some tolerably obvious documentation one would have expected to be deployed. But in any event, that general observation aside, I say, forgive me, I'll harp on slightly more about that general observation. One might have been mistaken if one stumbled across the feed of today thinking that we were in the Employment Tribunal. Such was the reference to first instance documents and submissions on the nuances to be given to emails without the presence of the witnesses, without them being cross-examined. What in essence, I say, is occurring is the respondent seeking to remake the decisions that went against them. The submissions as to distinctions between the evidential comparators and the claimant, we have been through Mr. Livingston's closing submissions, were submissions that were made below. They were before the tribunal, and that is their purview. In my respectful submission, it is not an error of law if they hear those and reject those. Turning, if I may, to the first 2 stages, findings of fact and the gravity assessment. Firstly, in relation to HM swearing in November 2018, forgive me, the Employment Tribunal makes its findings of fact at paragraph 14 on page 112, finding that HM swore on the telephone, overheard by several members of staff, which she accepted was unprofessional and inappropriate, which we say is a contrast to the claimant who never accepted, though it's difficult to accept such unformed allegations or that she had done anything wrong. And they also make a finding at paragraph 14 of the response. The response was that Miss Lake took no action. In relation to the swearing, there is then a finding as to the gravity. That is at paragraph 70.1 of the judgment at page 121, the tribunal say this was undoubtedly inappropriate conduct because, amongst other things, it necessitated Miss Lake going to see Miss Manning personally. So there is a finding as to what occurred, there is an assessment of the gravity. Then one turns, if I may, to HM's second matter, that is the email in November 2018, which caused consternation. And the context against which this occurs is the work which the department in which the claimant and Miss Manning did. They are departments that are responsible for the assessment and the provision of care of a whole series of vulnerable adults, including the physically, mentally less able and the vulnerable, guarding against signs of abuse and neglect, shortly put, where the safety of those service users that they might be referred to is in jeopardy if provision is not made properly. Against that background, we see the findings of the tribunal at page 113, paragraph 15, that 10 minutes before the end of the working day, on the day before the claimant was due to go on leave, HM sent an email saying that some of her team's work would be transferred to the claimant's team. So at the end of the day, and the tribunal finds at paragraph 15, that was a step that HM had no power to take, perhaps unsurprisingly so. The reaction was very significant, as the tribunal find at paragraph 116. One recipient of that email described that action of HM as being completely unfeasible. Another wrote, enforcing such a move without due consideration of the existing resource is dangerous and will lead to unsafe practices, putting service users at risk. You may feel that this instance alone is sufficient to shift the burden of proof, but it does not end there. Ms. Parmar objected to this as bullying at paragraph 17 on page 113, she put in a written complaint stating, I find it appalling that HM took the opportunity of me being away for 2 weeks to harass and bully my team leaders. This has now become a pattern, as you will remember from earlier this year. So not just that instance, but that instance as an indication of an ongoing pattern. And then there was a further written complaint by the claimant on the 8th of January at page 113, paragraph 19, forgive me, where the claimant described the actions of HM as kicking the team leaders of Locality West. And yet further complaints collectively this time from the team leaders at page 113, paragraph 20, where the team leaders complain that this was oppressive, there we are, that word has no monopoly, and inequitable treatment we found ourselves subjected to on 2 occasions. We feel there's been clear antipathy shown towards the West team leaders without any constructive assertions proffered being circumnavigated in favour of personal criticism. So a clear raising of a dangerous situation that led to a significant collective grievance in the context of provision for service workers that is safety critical. And the tribunal make those findings a fact, and then they assess the gravity. I beg your pardon. At paragraph, page 121, paragraph 70.2, if you'll excuse me. The tribunal make the finding entirely permissible in the circumstances that this caused such consternation it led to a grievance, and the manner in which it was done clearly offended others to the extent that a collective grievance was necessary. And I'll come to the comparisons with the claimant shortly, but to shortcut it, they find at paragraph 70.2 there was nothing equally serious against the claimant. And then the third example, my lord and ladies, is JR humiliating JD. That is, the findings of fact are at, forgive me, JD, there we go, I've made exactly the mistake with a friend.
Yes.
Exactly the trap he set up for me by transposing them. paragraphs 21 to 23, JD humiliating and denigrating JR. At paragraphs 21 to 23, JR stated she was publicly humiliated by JD in a training session. The appellants seek to downplay this, but the respondents have a code of conduct that says they take bullying and harassment seriously, and her description, JD's description of JR's behaviour as set out in the paragraphs is designed to cause humiliation and to denigrate this. I have formally raised it. And they make the finding that Ms. Lake's response, again, was not to institute disciplinary proceedings or disciplinary investigation, but was to offer mediation. And then there is an assessment of gravity of that. Page 121, paragraph 70.3, the tribunal found, as they were entitled to find in relation to this allegation, that JD, a team leader, so below the level of the claimant, made a strong allegation and said that she felt publicly humiliated in a training course, and mediation was the response. So I say that in relation to the evidential comparators, it cannot be said there is no comparison. It cannot be said there is no sufficient comparison. The Employment Tribunal go on specifically to make that comparison expressly, both generally and specifically. Having made their findings as to what occurred and the gravity of what occurred, both the allegations and the response, they then find at paragraph 70 at page 120, in a number of comparable situations where a disciplinary investigation might reasonably be instigated, Ms. Lake chose not to do so when it involved employees of a different race than that of the claimant. Instead, her normal approach was to offer mediation or deal informally with the issue. And then at paragraph 76, we conclude on the evidence when it came to assessing the merits of behaviour allegations against white employees, such as specifically naming those three, Ms. Lake was slow to move to formal measures. In the case of the claimant, she moved fairly speedily to investigation and suspension for something which was either at the same or lower level of alleged misconduct. So a granular series of findings, what occurred, what is the weight to be accorded to what occurred, and then a comparison generally overall. There are specific comparisons as well. I think I've taken in some of those as I've gone. Paragraph 70.1 in relation to HM swearing, undoubtedly inappropriate. In relation to the HM email, I think I've already referred to the consternation it caused as the tribunal found and the offence it caused, and there was nothing equally serious. And in relation to the JR allegation, that it was a strong allegation. So the ET then, having made their granular findings as to what occurred in relation to the non-Asian employees, they then go on to make their findings about the claimant's actions and her treatment, and they carry out a weighted assessment of that. They do that at 29 to 40, but at page 121, they find the reality is that there was nothing of substance to start a disciplinary hearing in respect of the allegations against the claimant. And in relation to my learned friend Mr. Allen made the point at one point that, well, possibly that's an erroneous error to a retrospective decision that is made once the investigation has taken place. But there is a passage where the tribunal also say, forgive me, I will find it, where they say that it must have been obvious to Ms. Lake that there was nothing in these.
It's the same paragraph, top of page 122.
Oh, most grateful. Most grateful.
Ms. Lake must have appreciated there was nothing of substance.
Indeed. So a fundamental a fundamental problem ab initio, or from the start, with the idea that that this process should have started and continued. I say, in relation to this ground, the ET expressly considered each comparable situation correctly directing itself as to the law. made findings as to the circumstances, compared them generally and specifically, simply cannot be said in those circumstances that the tribunal did not arrive at findings they were permitted to do in light of the role of the tribunal.
Yeah.
I won't describe Greenberg as being charity. It is a recognition of the vital fact-finding role of a tribunal. And if you're not to be dancing on the head of a pin on appeals, on a finely sliced version of appeals, that I say, Judge, my Lord, my lady, is the correct approach to take.
Sorry to interrupt, Mr. Pansall. Can I just ask you, what were the behaviour allegations against AE? Because AE is one of the three people who is referred to in paragraph 76. I think it's pretty clear that the reference in the second line of paragraph 76 to JR is a typo. It should be a reference to JD. But can you just help me with what the allegations?
So the original findings against AE is that it's at 70.6 onwards. Let me turn to that.
70.6? No, that doesn't. It's
No,
only
I think-
0.5,
I
is
think-
it? 70.5?
Yes, I think that was the allegation that the claimant had escalated matters beyond all possibility or beyond all reasonableness.
Is this para 27? Is that where we get the findings? And 29,
Yes, that's right.
31, 33.
Yes, the essence one can see, milady, of the AE allegation is that Ms. Parmar comes upon a situation where AE is said to have missed I think it was a safeguarding alert. She takes a much more moderate approach than Ms. Lake would have taken and says, well, this is a difference of opinion of when these alerts should be logged.
Yeah.
And what I will do is seek the opinion of a principal social worker. That then is objected to or retaliated against by AE in very stringent terms, offering her resignation. And but the tribunal come to the very firm conclusion that Ms. Parmar had done absolutely nothing wrong in that regard. Thank you, Lord, for your assistance in that regard. So, Lord, we have been through the assertions now made as to the granular distinctions between the comparators and the claimants that are made. Here, I say this is not the place to make it. The respondent made those, they had their chance. The tribunal correctly directing itself as the law heard them, considered them, and rejected them. And it is no point of law. It is a perversity appeal. I was waiting for perversity to raid its dread head, albeit it expressly not being a ground of appeal. It did so, I think I recorded at 11:46, when the true nature of this appeal, in my respectful submission, was revealed when Mr. Allen described the tribunal's decision as perverse. That, I say, is the reality of the nature of this appeal, not points of law. The second part, my lord and ladies, of ground one is in relation to the finding about Asian employees. That the other employees subjected to disciplinary proceedings were Asians. And I say there are a number of points to make about that. Firstly, it is obviously, in my respectful submission, a relevant comment to make in the context of a race discrimination claim when you are looking specifically in relation to Ms. Lake, who is accused of commencing a disciplinary process because of race, to ask the respondent through a subject access request, well, please provide us the pattern. Is there anything to rebut that? Are there other white employees who are subjected to similar treatment? And the response came back, there is not. The only two others are Asian. Do I say that would itself be enough to shift the burden? I do not, but I say the burden had been flown past. Those fences had been cleared by this point, and it was not a matter to be ignored. The respondents say the sample is too small to be of statistical relevance. However, the Employment Tribunal determines matters in relation to all sizes of undertakings. It will be a rare happy circumstance for a claimant when there is statistical evidence, and I would pray in aid His Honour Judge Taylor's statement at paragraph 79 of his judgment, where he says there is no proper basis for the contention that only the treatment of other employees that involves a sample of sufficient size that it can be said to be statistically relevant can be taken into account. So I say, my Lord and Ladies, it is a matter that could be taken into account. The statistical point adds nothing. It made no difference, and it was open to the respondents, having had this matter revealed of these other Asian employees, but only by way of a subject access request, to provide chapter and verse to say, here is the documentation.
I think they said they didn't have that information, didn't they?
Well,
They didn't keep BAME information.
I'm not quite
Didn't they
sure
say
that
that?
was quite what was said, my Lord. I know that was said in relation to the disclosure point in the judgment cited of the EAT judgment.
Paragraph 53. Council does not hold information on the number of white and BAME employees from grade 10 above.
Yeah, prior to 2017.
Oh, I see.
Yes. So there's a sort of guillotine in terms of time. However,
Yeah.
after that point, there is a period of years when the search is carried out. It reveals this, and it's not a freestanding point. It's a point that clearly can be taken into account. And what is said about discrimination is when the burden shifts, or the respondent who holds the material is expected to give a cogent response. And they don't have to retain that response until after the shifting of the burden of proof. It was open to the respondent to say, here are 100 documents as to the circumstances in which those employees were disciplined, but we say they're distinct. They did not do so. One sees the Delphic answers, and Delphic, I would say, categorises much of the respondent's approaches, whether disclosure or otherwise. So in those circumstances, it's an obviously relevant matter in relation to which the respondent does not play cards on the table. It is more akin to the three-card trick with the cards being shuffled. I put that no more highly, my Lord, other than matters that could have been disclosed were not disclosed, and it doesn't sit well with the respondent in those circumstances to say it's not a matter that could have been taken into account. Lord,
I'm so sorry to interrupt again, Mr. Pansar. I didn't catch the reference, the paragraph reference from the EAT judgment.
Yes, so forgive me, I thought His Lordship was referring to paragraph 38 of De Silva and Natfi. That was that distinct case where...
No, I'm so sorry, I haven't made my question clear. A moment ago, you referred to a paragraph in the EAT's judgment in this case.
I beg your pardon, yes, that was...
which
His Honour
Judge
Judge
Taylor refers to
Taylor.
statistics. I just wanted the paragraph reference, please.
Just let me double check that's the one.
My fault, I just
No,
didn't note it down.
I was going at a pace, I fear. Yes, it was paragraph 79. I'm grateful.
Paragraph
to Miss
70
Crawshay
79.
Williams. Yes.
Thank you.
No proper basis for the contention about statistics.
Lovely, thank you.
All right.
I can think of nothing else to say, my Lord, unless there are other matters that I could usefully address you on.
Thank you very much.
Most grateful.
Mr. Adams, you wish to reply?
Yes, very briefly, just on a couple of points. The first one is just, I think, a factual one. There was a question, my Lord, where do we find the findings of fact in relation to AE? And the paragraph numbers that were arrived at were 27, 29, and 31 to 34, which are all paragraphs with findings of fact about AE. But they are all paragraphs in which AE's role is of being a complainant, not a person accused of misbehaviour. It was suggested that AE is someone that the tribunal made a finding about having missed something relating to safeguarding. There was no evidence or finding that AE missed anything, and it is recorded in paragraph 29 of the tribunal's judgment that the email began with JR. This is line 4 of paragraph 29. The email began with JR pointing out to SR that a safeguarding alert had apparently been missed. AE was the manager of SR, which is why she gets involved. I just want to avoid any finding from this
I accept that.
from this court, which suggests that AE has done something wrong, or that there was a finding that she had done something wrong. On a different point, I just wanted to make the point that my friend has made no suggestion in his submissions that the Employment Tribunal's reasons reveal anywhere where differences between any of these supposed comparators are discussed. And my Lord, if you will forgive me, I'm just going to turn around to see if Mr. Livingston has anything that he wanted me to add in addition to those points. Thank you, I had no other points to make.
Thank you very much. Well, we will reserve our judgments. We will get a draft in the usual way. The draft is your opportunity to correct our English and spelling, but not to raise arguments or criticise our reasoning. The draft will come with a strict embargo, which means what it says, so it can only be distributed to those on our distribution lists. In the light of the drafts, we would hope that you will agree an order disposing of the appeal. If you can't agree a form of order, please make short written submissions and we will make the form of order that we consider to be appropriate. The eventual hand down of the judgment will be electronically by release to those on the distribution list and publication on the National Archives site, so there will be no need for any further attendance. Thank you all very much.
Can I just add a piece of information which might be useful, which is that Employment Judge Ahmed, as I understand it from the HMCTS website, has now retired. It's something which may be relevant to the issue of disposal. I'm grateful.
Thank you.
Dan.